Today we're deep diving into Florida gun law. Specifically, we're going to talk about the statute that makes it lawful for a person without a concealed carry permit to carry a concealed handgun inside their vehicle. We're going to do more than just answer the question, can you? We're going to explain the law so that way you can feel comfortable in your decision and confident that you're in compliance with the law as you drive down the street. I want to know what you think the law is before you watch this video. Put those in the comments before we get started. If you'd like to get my notes on this, I'll put a link down below. Click the link, enter your email address, we'll email you the document. If you stick around to the end, I'm going to share with you my thoughts and my suggestions on how to tell a police officer that you have a firearm in your vehicle. If we haven't met yet, my name's Jeff Lauder. I'm a Florida licensed attorney based out of Orlando, Florida. I use my 18 years in law enforcement as experience and background to help people navigate life's most complicated problems. If you or someone you care about is looking to hire a lawyer in Florida, send me a text. If I can't help you, I'll find someone that can. So let's take an overview look at this statute because we're going to be referencing multiple parts of it, and it's probably best that you have a good understanding of the overall construction. So the actual statute that we're talking about here is Florida State Statute 790.25, lawful ownership, possession, and use of firearms and other weapons. The statute is broken down into 5 different sections. The 5th section is the most critical for our discussion, but I want you to have an understanding of all of them. So we're just going to highlight real quick through it. Subsection 1 is going to be declaration of policy. This is where the legislator tells the courts what their intent of this particular statute was. So not really critical for us. Number 2 is critical for us. So we need to understand subsection 2 is who's not authorized or who's not protected by this particular statute, 790.25. Subsection 3 is lawful uses. I've already done a video on that. It's the open carry video. I'll put a link to that. Subsection 4 is a liberal construction cause. Essentially, the legislator says, hey, if you have any questions or any doubts about anything in here, you should interpret this in favor of legal gun ownership. So you should interpret this in favor of the gun owner. Subsection 5, that's what we're going to dive deep into. It is possession in a private conveyance. So let's do that now. So this first sentence of the statute is really dense, and we're going to read it over once, and then we're going to break it down. So just bear with me for a second. Possession in a private conveyance. Notwithstanding subsection 2, it is lawful and not a violation of statute 790.01 for a person 18 years or older to possess a concealed firearm or other weapon for self-defense or other lawful purpose within the interior of a private conveyance without a license if the firearm or other weapon is securely encased or is otherwise not readily accessible for immediate use. Wow, that's a lot. All right, let's break this down. Notwithstanding subsection 2. We already talked about the subsection. Remember, subsection 2 was that unlawful use segment. Well, I think, and really this means notwithstanding subsection 2A, and it's a big deal, but it's a mistake in the statute. It's not pertinent for this particular conversation. But notwithstanding subsection 2, it is lawful and not a violation of 790.01. That's the concealed carry law. It is not a violation of the concealed carry law if the person's 18 years or older and for the purpose of self-defense or other lawful purpose. So let's just say self-defense. You are carrying this handgun. We're using the word handgun for self-defense within the interior of a private conveyance. It doesn't say on your person. It says within the interior of the private conveyance without a license. If the firearm or other weapon is securely encased, we'll get to that definition in a minute, or is otherwise not readily accessible. So first footnote there, 18 years old. Easy. We got that threshold. Probably everybody watching this is over 18 years old. The second threshold here is interior of the vehicle. This does not authorize you to carry a gun on your hip inside your car. It does not authorize that. And if you're doing that, you're violating this law. Now, let's go to the definition of securely encased. Securely encased means in a glove compartment, whether or not locked, snapped in a holster, in a gun case, whether or not locked, in a zippered gun case, or in a closed box or container which requires a lid or a cover to be opened for access. All right, that's what securely encased means. That's pretty clear. I think we can have an objective standard there and understand what we're looking at. So I like that. Let's look to the second part of that statute because we have an alternative here. So we do securely encased or otherwise not readily accessible for immediate use. Do not use this. Use securely encased. This otherwise not readily accessible for immediate use is so subjective, and the courts have ruled very anti-gun on this. So what does readily accessible for immediate use mean? Let's go to the definitions section. Let's look at what it says here. Readily accessible for immediate use means that a firearm or other weapon is carried on the person or within such close proximity and in such a manner that it can be retrieved and used as easily and as quickly as if carried on the person. Okay, so if I have a gun in my holster, in a Serpa holster, I can be on target just like that, putting rounds down range. My understanding of this would be having a gun in a level 2 holster sitting on your passenger seat. It would be securely encased, yes, so we'd meet that part of it, but it would also be not readily accessible for immediate use because that would require me to use 2 hands to get the firearm out instead of using the body mechanics. You know, the holster being tied to the side and locked in the waist and pulling that out. So it would require 2 hands. So my definition, that would be met there. The courts are looking at this in a totally different way. The courts have ruled quite the opposite, that even having your ammunition and your firearm in 2 separate spots in the car, that would require the extra step of loading them, racking around and doing all those steps or taking all those actions, that's still readily accessible for immediate use. So, I mean, I'm sure I get firearms experts to argue the other side, but the court's already against you. And besides, we have an easy answer. Just put it in a holster. You want it securely encased anyway. So it's a no-brainer to go the securely encased route if you're carrying a gun in your car. No-brainer. Okay, so we have the baseline down. We know you got to be 18 years or older, and that it's concealed within the vehicle, and it has to be for the purpose of self-defense, which is fine, or any other lawful purpose. You don't have to have a license, so there's no concealed carry permit required, but the firearm has to be securely encased. We're going to ignore that other part. It has to be securely encased, and we know the definition of securely encased: in a glove compartment, whether or not locked, snapped in a holster, in a gun case, whether or not locked, in a zippered gun case, or in a closed box or container which requires a lid cover to be opened for access. Okay, let's move on to the next sentence. I think we beat that sentence up to death. So, nothing herein contained prohibits the carrying of a legal firearm other than a handgun anywhere in a private conveyance when such firearm is being carried for lawful use. So there's different rules for handguns and other guns. What we discussed so far, and the only thing we're discussing today, is the carry of handguns. Everything we've said so far is towards handguns. Rules are a little more lenient for other types of firearms and other types of weapons. Next sentence. Nothing herein contained shall be construed to authorize the carrying of a concealed firearm or other weapon on the person. So once again, the legislator is emphasizing this statute does not give you the authority to carry the gun on your person. It's in the vehicle, secured or encased within the vehicle. having your center console in a holster. Got to protect that trigger. Let's move on to that last sentence. This subsection shall be liberally construed in favor of lawful use, ownership, and possession of firearms and other weapons, including lawful self-defense. Gotta love Florida. The legislator has written it in the statute 4 different times, that they want people to be able to lawfully own guns for the purpose of self-defense in Florida. Correct me if you think I got something wrong here. What did you think the law was before you watched this video? That's what I want to know. Let me know that in the comments. So now we move on to the question, do you have to tell the police officers if you're pulled over on the side of the road? And the default answer to that is no. You're not required to tell them that you have the gun in the car. In fact, in most circumstances, I was just not even bringing it up. But that is based on the idea that the police officer is not going to see the firearm that you have concealed. Don't open the glove box and have the gun exposed and not tell the police officer in advance. But if you're carrying a gun in your car, you should probably have your documentation in order so it's not sitting by the gun, so you'd risk that behavior in the first place. So on a traditional traffic stop, going to be in and out, get your speeding ticket, get your warning, whatever is going to happen, and you're on your way, no, I probably wouldn't say anything. But if for whatever reason the traffic stop is delayed, or you're suspicious, or for whatever reason, it's just unusual circumstance and not a traditional traffic stop, then I would probably default towards telling the police officer. Now, the way you tell the police officer, I think, is important too. You're going to be amped up and nervous because you're pulled over, and this doesn't happen on a regular basis. What I've seen happen many, many times is that they say, I've got a gun in the car, and then they start to go to show me and open the glove box just to show me where the gun is. They don't plan on touching it, but that movement is not something you want to do. You're going to be putting the officer into red alert mode when you do that. You don't want to trigger that fight or flight response in the police officer. So here's what I suggest you do. Take your hands. Put them together so the tips of your fingers are touching. This is what the police officers call the interview stance in the police academy. Stand with your feet shoulder width apart, fingertips together like this. It is a prepared stance, but it is not an aggressive stance. I only show you this because they will recognize this as something familiar to them, and it will trigger friendly thoughts in their subconscious. They will also, if you focus pressing your fingertips together, will prevent you from reaching over and opening where the gun would be. So it has two parts there. If you can remember to do that, it's probably the ideal way to do it. Just tell the police officer, don't reach, wait for instructions. I'm curious, what experiences have you had from officers when you've told them that you've had a gun in the car? They tell you to get out of the car, they tell you not to touch it, did they ask you any questions? Leave that down below in the comments. I have a question for you. What's your understanding of Florida's 3-step law? It's kind of a trick question. We'll see if you get it.